Hello, everyone. Welcome to the Alliance Against Violence and Adversities, or AVA's, Webinar Wednesdays. This webinar is co-hosted by the Frida Center for Research on Violence Against Women and Children, housed in the School of Criminology at Simon Fraser University. I'm your host, Dr. Sarah Yersich. I'm an early career researcher and lead on the webinar series with the Alliance Against Violence and Adversity, as well as the co-director of Frida and faculty at Capilano University. I want to begin by acknowledging that, on a national level, we encourage all Canadians and visitors to Canada to learn about the Indigenous peoples of the lands on which they live, work, or visit, and become engaged allies together. We, as Canadians, in the spirit of truth and reconciliation, respect the self-determinations of First Nations, Métis, and Inuit peoples, and their rights and responsibilities in cultures, languages, and the pursuit of wellness. Before I introduce our speaker, I'll share just a couple of things. First and foremost, this webinar is being recorded, which means you can revisit it and share it at any time. Over the next couple of weeks, it will be posted to AVA's YouTube channel. I will also be sharing the link to the YouTube channel in the chat momentarily so that you can see our upcoming webinars and also revisit the past webinars. The chat function, you'll notice, has been disabled. However, throughout the presentation, if you run into technical issues, you can reach myself or Jason using the Q&A function. Please also, as our speaker is talking, if questions arise for you, put them in the Q&A box, and Mandi will make time at the end of her talk to answer any questions that you have for her. The focus of today's webinar is Suing for Silence, Sexual Violence and Defamation Law in Canada, featuring Mandi Gray from Trent University. Dr. Mandi Gray is an assistant professor at Trent University in the sociology department. Mandi has worked with women and girls involved in the legal system since 2008. Suing for Silence is her first book, and I can assure you it's a very good read. She is also the primary subject and impact producer of the 2018 documentary Slut or Nut, The Diary of a Rape Trial. Her work has appeared in publications including Toronto Star, CBC, Globe and Mail, and Toronto Life. Mandi is originally from Winnipeg, but has called Toronto her home since 2013, where she lives with her sassy little dog, Cece. Mandi, without further ado, I'd love to pass it over to you, and thank you so much for joining us today.
Thank you so much for having me in the introduction, Sarah. I really appreciate being able to talk about this work. As I mentioned, I haven't done any presentations on this work in several months, and it's nice to get back and talk about this research and the research that I've been doing since writing the book. So as mentioned, the focus of this presentation today is going to be on my book, Suing for Silence, Sexual Violence and Defamation Law. It was published in March 2024 by UBC Press. For anybody here today, you're welcome to use the discount code SILENCE at ubcpress.ca. I think the discount code should be good for about 2 weeks after this webinar, if you want to order the book after I talk a bit more about it. I'm going to begin the presentation giving you a bit of background of how I came to this area of research, a bit more about me and my kind of entry into why I wanted to write this book, and my own positionality as both a researcher and advocate for people who have experienced gender-based violence. I started my career in 2008 working in Winnipeg's North End at the Elizabeth Fry Society of Manitoba. I provided direct support and advocacy to incarcerated women. A vast majority of incarcerated women have disclosed that they've experienced sexual abuse throughout their lifetime. And so while this wasn't the direct part of my job, it was often a big part of the stories of the women that I met who were either coming into custody or leaving custody, and many of the challenges that they faced throughout the course of their lifetime. In around 2015, when I was starting my PhD at York University, is when I began to focus my research more explicitly on sexual violence, reporting sexual violence, and institutional responses to disclosures. I did a lot of advocacy work. I'm often featured in Canadian media, as mentioned by Sarah in my bio, and as a result of being public-facing advocate around these issues, I often received messages on social media from women, really internationally. In around 2007, I received a message from this woman named Lynn. Lynn is a tattoo artist based in Montreal, and her story was particularly surprising to me. She was so grateful for the ways that I had used my voice very publicly to speak out around sexual and gender-based violence because she had felt had been silenced in her own life. So she told me if I was ever in Montreal, she would tattoo me for free in order to thank me for the advocacy work that I had done. As you can maybe see, I am very tattooed. And so as she was tattooing me, she began telling me about how she had been silenced when she was living in France. She was apprenticing as a tattoo artist and was sexually assaulted by her boss, the person that what she was apprenticing under. She reported the boss to the police and it went to trial in France, in French, which was her second language. He was eventually acquitted, but in France at the time, when somebody is acquitted of sexual assault, there is the potential for the man accused to both criminally charge and sue his accuser at the same time. So Lynn was then facing criminal charges, the potential for a period of incarceration, as well as a lawsuit against her, which would be a monetary fine. So Lynn got a lawyer, she fought these charges, and she was eventually acquitted by the court as well. But this left her in a very interesting space because while the courts had said that she was not sexually assaulted beyond a reasonable doubt, the courts had also said that she did not lie or fabricate the allegations of sexual assault. And this left her in this gray area where she felt really fearful about talking about what had happened to her during her time in France. And of course, I was horrified by this. I didn't know that this was a possibility. And I also assumed that this was something that was happening elsewhere, but wasn't happening here in Canada because at the time I had been working within the legal system for about 7 years, and I didn't realize that it was a possibility to be sued for making a report to police or to the workplace or university. Later that same summer, I met another woman, a very young woman at the beginning of her career, who also shared with me that she had made a formal report that her boss was sexually harassing her in the workplace. And in turn, she was fired from her job and served with a lawsuit. Like Lynn, the lawsuit had such a significant impact on this young woman's career, her well-being, and her willingness to even engage generally about conversations around sexual violence. And to give you kind of the political landscape in which this was happening, the Jian Ghomeshi trial had just wrapped up. There was just a growing discourse about campus sexual violence. And so it was something not to the same extent that we saw it with Me Too, but we were seeing growing traction around the issue. And that's really where the project began in 2017 with this woman who told me that she had been sued in Toronto, and I had really not been even aware that this was a possibility. I talked to Joanna Birnbaum, who's a very prolific civil litigator in the area of civil sexual violence, if she was aware of anyone being sued for reporting sexual assault in her practice. And at the time, she told me she was representing 3 women, all of whom had made formal reports either to the workplace or to police and were then being sued by their perpetrators. Unfortunately, since that time, Joanna's practice has really grown in this area, and she's probably one of the leading lawyers representing women being sued for reporting sexual violence. And I just want to talk a bit about the art that I have incorporated into the presentation. So this is a piece of work, and it was created by an anonymous woman that I met during my research. She is a professional artist, but she's no longer able to show her work under her own name due to a lawsuit against her. The lawsuit stems from an art show that she had done that premiered in New York City. And although she did not name the man, that the artwork was about. He later sued her for defamation, alleging that everyone was well aware that he was the this kind of inspiration for this artwork. And now, as you can imagine, a professional artist who is no longer able to show her work is then subjected to a defamation lawsuit, can have very significant professional consequences as well as emotional and financial. The collection of work is called Dead, and it reflects a series of discriminatory language used by lawyers in court to describe people who have reported sexual violence. The pieces that I'm going to show in the presentation are not a part of the lawsuit against her. It's from a new body of work, but she is unable to attribute her name to this body of work as a result of the litigation against her. And I guess on a matter of personal experience, so while I had an interest in these lawsuits and I began writing the book in around early 2018 is when I started this research into this work is, and the day I submitted my proposal to begin this research was the day that I sat down at York University where I was doing my PhD and got a call from Joanna Birnbaum, the lawyer that I had mentioned. And it's like never a great day when you get an unexpected call from a lawyer. And she asked me if I had seen the National Post because I was being sued for defamation myself, for attending an art show and for posting tweets in relation to a public news story about a professor who had been accused of sexual misconduct and was subsequently under investigation. And just to give you a sense of the length of time that it takes for these lawsuits to resolve, I found out that I was being sued in November of 2018. In that amount of time, I was able to finish my PhD, get a postdoc at the University of Calgary, complete my postdoc, publish my book, and I'm now assistant professor at a university, and the lawsuit is still ongoing. It's nearly 7 years later. So I do also bring in personal experience of navigating the civil legal system as a defendant. So this also coincides with the rise of the Me Too movement. So as I'm sure all of you have heard of the Me Too movement, I don't need to explain what it is. You'll know that the Me Too movement had a wide global influence, encouraging many people to share and report their experiences of gender-based violence. But what we also saw was backlash to the Me Too movement, and the backlash took many different forms, but the form that I'm going to be focusing on exclusively is the defamation suits that followed. And here are just several of the news headlines capturing the lawsuits that we really saw on a global scale, from, here in Canada. I've been tracking them globally. So Australia, India, Pakistan, South Korea, the UK, it's really had quite a global reach in terms of the use of defamation lawsuits as a direct response to allegations. And I think one thing I want to challenge that I think is a common assumption about my research is it is so frequently that people assume because of the Me Too movement that these lawsuits are emerging because women are getting on social media and naming and shaming, to use the language of media. But what my research has really revealed is really that's not an accurate reflection of what has happened. Almost all of the people that I interviewed who were sued by their perpetrator were sued after having reported to police, having made a formal report to their workplace or the university. In some of these cases, the men were even, felt found to be accountable. They lost their jobs in some instances because the allegations were in fact credible, or, the police never followed through with an investigation. And so social media was used in some of the cases when all other avenues were closed down to them, but not necessarily just going on social media as like the first step to join in this social movement. And I think that's a very big misconception that I even challenged myself in my own research, assuming that a majority of it would have been social media disclosures. So just to give you a very brief background on what defamation law is, I think it's a commonly used term, but I don't think a lot of people actually know the very low bar of what it takes to have a defamatory statement in Canadian law. So I'm not going to bore you with the specifics of defamation law or tort law, but rather just a high-level overview of what defamation law is and what its intention is. So defamation law was really the sole reason why it was created was centuries ago, and it was created really with the intention to discourage men from participating in bloody duels and encourage engagement in civil society. So this was a time when they really wanted to build up civil society and democracy and reduce the reliance on violence for when men experienced reputational harm. So defamation law was introduced with the sole intention of protecting reputation, and of course, with the intention of promoting engagement in civil society. So reputation is very, very highly valued by the legal system. The Supreme Court of Canada has recognized good reputation as being closely related to the worthiness of and dignity of an individual. And here is a quote from Hill versus the Church of Scientology, Toronto, which is one of the leading cases that has been released by the Supreme Court of Canada, and really set a very high bar for the types of damages that can potentially be awarded in a defamation case. Defamation is also very interesting in Canada because there is a very low threshold for what constitutes a defamatory statement. So if a so-called ordinary person would see that statement to lower your reputation, it is therefore considered to be defamatory. What is also really interesting about Canadian defamation law is that it is the only tort that the onus then falls on the person being sued to then prove that their statements were justified. So if you think of most other lawsuits, so for example, if I want to sue you for causing me physical harm due to negligence, it would be my responsibility as the plaintiff to demonstrate that you were negligent, and this is the extent of the harm that was caused to me. With defamation, that's reversed. The plaintiff only needs to demonstrate that the statements were made, whether spoken or written, and then the onus then falls on the defendant to prove that the statements were in fact justified. So there are several defenses that the defendant can rely on to defend themselves. I so often get messages from people who have experienced sexual violence, and they say, but if it's true, they can't sue me. And while truth is a defense to defamation, if what you are saying is true, it is not defamatory. However, you still have to prove the truth of those allegations. And so you can imagine this can be particularly difficult when the allegations involve sexual violence. Many of the same myths about sexual violence and discriminatory stereotypes that we see in the criminal legal system, liar, crazy, motivated by financial gain, celebrity status, are also very present in the civil legal system. But it hasn't really been examined critically to date. There really isn't a body of work that's looked at how sexual violence has been dealt with in the civil legal system. Much of the research and advocacy has really focused on the criminal side of things. I interviewed law professor Constance Backhouse at the University of Ottawa Law School when I was doing interviews for this project. And I asked her why defamation. And I thought this quote was really encapsulated the motivation. And she says, if you latch the ease of bringing a defamation action onto a culture that believes all women lie. A defamation suit is the knee-jerk reaction within a culture that does not believe women. The defamation lawsuit is very effective at then challenging the allegations being made and recasts the alleged perpetrator as the true victim of false allegations. And the defamation suit, there's nobody at the courthouse checking to the validity of the lawsuit. Anybody can go and initiate lawsuit, and can be an effective tool, especially for public figures who can then go in media and use the lawsuit as evidence that they are, in fact, the real victims. So overall, the civil legal system, as I mentioned, has been relatively unexplored by the social sciences. If there's any PhD students here in the social sciences, I think this could be a really rich area to look at. And if you think of defamation, it is inherently social. For a claim to be actionable, the statements must have been made to at least one other party. So that means that it is, in its very nature, is social. Moreover, we could argue that reputation is completely constructed. It's created by social relations and cultural norms, things like where you went to school, where do you work, your status in society, socioeconomics. So, at its core, legal scholar Jerome Skolnick has argued that reputation is about protecting how one's reputation is projected into society. Now I'm going to briefly look at one of the findings from the book to kind of look at the intersection between the criminal legal system's overall failure to adequately respond to reports of sexual violence and how the criminal law's failures has made individual people, primarily women, vulnerable to defamation lawsuits. And I'm going to start by sharing an experience of Catherine, who was very much emblematic of many of the people that I interviewed for Suing for Silence. And so the key finding or key thesis from this part of the book is that the overall systemic failure to respond to sexual violence creates vulnerability for defamation lawsuits. Catherine was a young woman that I met when I think in 2019 when I started doing interviews for the book. She's a woman of color in her 20s at the time. She lives in a large Canadian city and she was sexually assaulted by her partner. She reported the sexual assault to the police, but they never pursued charges. They never interviewed him. It really went nowhere. Several months later, Catherine learned that the same man was facing new charges for assaulting a different woman. And he agreed to a peace bond. So a peace bond can be a voluntary agreement, and it's very similar to a restraining order. Like you won't be in contact, you won't come in within a certain distance of one another. And so when Catherine learned about this peace bond, it's not necessarily an admission of guilt, but it's an admission of something happened between these two people, and now they are no longer to have any contact with one another. So when Catherine learned about this peace bond and given his role in their community, she posted about it on social media. He then sued her for defamation, and he also reported her to the police for online harassment. So while the police had never investigated her claims when she reported sexual assault, very, very quickly, the police called her and investigated her for the online harassment about posting about the peace bond. The police also threatened her with criminal charges if she were to continue posting online about him. And as I mentioned before, this is emblematic of a number of the women that I spoke to. This isn't just Catherine's experience. I have interviewed several women who were either threatened with charges or who have, in fact, faced criminal charges for reporting or doing what Catherine did and posting on social media after the reports were initially dismissed by official organizations such as police. And like just by pure chance, Catherine was calling around looking for representation, and she met a lawyer who was really compelled and frightened by this case and decided to represent her pro bono. The settlement discussions dragged on for many months. Talking too long. So they continued their settlement agreement, but there was a lot of challenges in getting him to settle. I'm just going to my notes one sec. But they did eventually come to what would be considered by legal professionals as a good settlement, in that both parties agreed to make a donation of several $1,000s to an anti-violence organization in their community. So, despite this seemingly favorable outcome, the lawsuit continued to haunt Catherine for many years later. She attributed the stress of the lawsuit to several health problems she later developed and the loss of the ability to feel safe, to the point where she was often suicidal. She was once really active on social media, which was a space where she found community and others that she could, disclose and share about her experiences of violence. But as a result of the threats of criminal charges and this lawsuit, she no longer felt she could participate in online communities or groups. In my interview with Catherine, she became quite upset and emotional when she was discussing the consequences of the lawsuit against her. And I'm just going to let everybody know that the next slide has a direct quote that references her suicidal ideation. So this is from Catherine. I'm still suicidal. I'm out of danger. But the thing that fucks me up is knowing that I live in a world where this happens, where this could happen to vulnerable people. The world is not equipped to help us or even believe us. Several participants shared similar experience to Catherine. She made a formal report to police and was denied any form of justice. She used social media to find her voice and find support after similar charges were laid in another case, and he did agree to a peace bond. And while the police did not investigate her claims of sexual assault, the police had no problem showing up at her door and threatening to charge her with harassment. The police threats, coupled with the lawsuit, effectively silenced Catherine, who in turn stopped engaging in online activities altogether. This was a quote from Lynn, who I introduced at the beginning of the presentation. She said, "I can't explain how huge my regret is for reporting to the police, how much regret you can be filled with for doing what you have been told is right, for defending yourself as a victim, trying to stick up for people, for yourself. Then, like, oh my God, I should have kept my fucking mouth shut. I shouldn't have gauged the legal system at all. I would be much happier and I would have back 7 years of my life. I am trying not to bawl." The Supreme Court of Canada has really had several decisions where they've been very, very explicit about the need to address stereotypes around sexual assault that, you know, severely impact women, but also have a differential impact on people who experience intersecting forms of marginalization in society. The Supreme Court of Canada has time and time again reiterated this in a number of decisions. Recently, in the decision of Barton, they write, "Without a doubt, eliminating myths, stereotypes, and sexual violence against women is one of the most pressing challenges we face as a society. While serious efforts are being made by a range of actors to address and remedy these failings, both within the criminal justice system, on campus, the workplace, and throughout Canadian society more broadly, this case attests to the fact that more needs to be done. Put simply, we can and must do better." And the court continues to acknowledge that the criminal legal system ought to be doing more to remedy these institutional failings to respond to sexual violence, especially in the cases where victims experience intersex. Sorry, guys, I don't know why my slides are doing that, but we'll be okay. Um, the court has really been provided many strong wording about the need to do better to better protect survivors of sexual violence. We can reflect on the experience of Catherine, who attempted to report sexual assault only to have her experience dismissed by police and then threatened with charges herself. And as I mentioned, this wasn't an isolated incident. And there's just so many numerous failures of these institutions to respond to and prevent sexual violence that has allowed for the initiation of defamation lawsuits and holds individual women then responsible to prove their allegations as true, often at their own financial expense. And there are many other consequences that are found within having to defend yourself in a lawsuit, as I write about in the book. Many of the women began to develop very severe health problems that they attributed to the severe stress of defending themselves in a lawsuit, as well as the financial element. There aren't organizations who provide services to help people who are sued in defamation. Just to give you a ballpark figure, you're looking at $100,000 to $200,000 to defend yourself. And that doesn't even include if the possibility of losing and then having to pay potentially him, the plaintiff, money, as well as legal costs, because the losing side will also be responsible for legal costs. And so there's all these institutional failures that are happening. And what I'm seeing is in the lower courts, there isn't much empathy for women who attempt to report, who are then being sued in defamation. And I'll be happy to talk more about that and what I've been seeing more recently. I have been continuing to do interviews in this area. I received a SSHRC grant in June, and I've done about 20 more interviews with people who have been sued in defamation. And I would say that this is an increasingly common tactic that I'm seeing be utilized by men who are accused of sexual violence. And more worryingly is when those reports are made to police. So that leads me to my next slide of how is this allowed? And without getting into the very nitty-gritty of defamation law, essentially police reports are not protected from defamation actions. You can be sued for reporting to police. You can rely on the defense of qualified privilege. However, there will be no guarantee that this defense will be successful. And as I mentioned before, even if the case goes to trial, you still have to pay money to get it to trial. And this will be incredibly expensive and time consuming, often taking, as I mentioned before, 5 to 10 years potentially. And so I'll talk very briefly about what is referred to as anti-SLAPP legislation. So this is legislation that is in both British Columbia and Ontario. And SLAPP refers to strategic lawsuits against public participation. And that is really intended, in theory, to give defendants a really quick and affordable way to have lawsuits that are argued to have public importance and an affordable and quick route to have the lawsuit dismissed, which is weighed against the need for reputational protection. So the courts are asked then, is this speech a matter of public interest? And if it is the public interest in of more importance than the reputational protection of the individual? So there's been over the course of since the legislation came into effect, there's been I'd say a good number of anti-SLAPP motions to attempt to have defamation lawsuits dismissed by the courts. Several of these lawsuits that involve formal reports to police have been dismissed using the anti-SLAPP legislation, but there's still a lot of work to be done in this area. And it is also important to stress that these motions are neither quick nor cheap, as promised when the legislation first passed. But what I am seeing and what has been consistent since writing the book is that the courts have been more likely to dismiss when the survivor, the individual, makes a formal report to police. Um, but I haven't seen any cases yet where the courts have been willing to dismiss when the reports are made broadly, whether it be on social media or whether it be to multiple friends or acquaintances. So it is still very much this assumption of like the good victim who tells the authorities, the police, and doesn't isn't angry about it and is not, telling a whole bunch of people about what happened to them. So there is some success stories with this new legislation, but then, of course, not all provinces have this type of legal protection available. And there are plenty of cases where the SLAPP motion has not been successful. So, for example, in the case of Stephen Galloway, for example, while some of the defamation lawsuits were dismissed, many of them were not, including the report that the complainant made to, or I should say defended, but was complainant when reporting to the university. So I guess in conclusion, I think it's really important to stress that although defamation lawsuits appear to be growing in terms of number of men relying on them to dispute the allegations against them, they do remain relatively rare in comparison to the number of people who report and experience sexual assault. But it is a growing tactic, and it is one that I think both service providers and people who experience sexual violence need to be aware of, that they need to be told that your report to police is not protected from litigation. This is particularly important if the perpetrator is in a position of privilege and power and has financial resources. And it is really unfortunate that at this time, when people ask me the likelihood of being sued, it is really a weighing of the possibilities of, do they have the financial resources to do so? I've also been seeing men without representation initiating or not civil suits, but small claims actions against people who have reported them to police, and then they're self-representing. Um, and that I also argue that defamation lawsuits really do make individuals who have experienced sexual violence responsible for the many failures of the criminal legal system. And then it becomes the sole responsibility of survivors to defend themselves as a result of larger systemic failures that have really, really failed these women, failed to take their reports, failed to investigate their reports. Or even, the bare minimum to take these reports seriously. And then the failure to do so is then used as evidence that she is lying or making false accusations. Ultimately, and if anyone has questions, I'm happy to talk more about this, is there's really an urgent need to better protect formal reports from defamation. That's one of the key arguments I make in the book. We as a society cannot continue to encourage people to report to police without also giving them information about the potential consequences of doing so. It's really unfair to survivors that they are not told that they can be sued if they make a formal report. But I also think as advocates and as society more generally, I think we really need to challenge the legislation and create protections if we are to encourage using the criminal legal system which I'm also not convinced of and happy to talk. I'm doing a lot of other work on non-carceral, non-legal alternatives for sexual harm, which I'm also happy to talk about in the question and answer period. Because after having done this work for so long, I'm not, although I want I want everybody to have the option to report to police and it be protected. I still am not convinced that that's the best avenue for the typical justice needs that survivors typically report after experiencing sexual harm. Thank you all for listening to me. I am going to open it up for questions, or you can put it in the chat. I can't remember, Jason, can people unmute or is it just through text?
It would be through the Q&A function, so by
Okay.
text.
There's a Q&A webinar function, so I'm happy to read your questions and then respond. And as mentioned, yeah, I have a discount code if you're interested in reading more about my book. And I forgot to mention another piece. Myself and lawyer Lil Kadu Shah are received a grant, and we are working on a website right now. It'll be called defamationdefensehub.ca. And we are creating kind of a database for lawyers and other advocates, survivors who are self-representing. It will have all the necessary kind of legal documents that you're going to need to better understand the law in this area. And we decided to create that because there really is very, very minimal resources available online that can really guide you through what to expect after being served with a notice of civil claim. And just given how cost prohibitive it is to retain counsel and be represented, we wanted to make the case law relatively accessible to folks to better understand like what is considered defamatory speech, and the threshold for the different defenses, as well as like case summaries of all the defamation decisions across Canada and tracking the defamation litigation more globally. So we had anticipated that being launched in June. But as you know how these academic projects go, we are now anticipating a launch in the fall. You can register for my mailing list on my website, and I'll send out an email once we launch the site. I'm, yeah, looking forward to it. And if anyone has any recommendations for types of resources that would be helpful for non-lawyers to better understand the defamation law, please feel free to let us know because it would be really helpful as we begin to tailor the resources to the audience. Okay, I will now open it up for questions. Um, Jason, where do I see the questions? Oh, I see it now, sorry. Wondering about the application of defamation suits to bad date lists reports for sex workers. Should there be a concern, and how do we protect our community while sharing the info? That's a great question. So the question was around bad date lists and reports for sex workers. And this is actually really unfortunate because I have heard from several sex workers that, they've had and just so everybody knows, so a bad date list is when somebody who's purchasing sex behaves badly, robs them, sexually assaults them. It's just not somebody that other workers would want to engage with. And so these lists are intended to keep community safe. But yeah, I have seen men who are named on those lists or catch wind that they're named on those lists and then sending cease and desist letters, and or filing defamation suits, especially with digital lists if they get leaked. Or even if you, as I mentioned, defamation, the bar is so low, is that even if you communicate to one other person, it only takes communication to one other person for it to be actionable. So it is a very big concern amongst sex workers. I think the only real benefit or benefit, and put in quotations, would be that um, men maybe or men want to protect their, reputation in terms of like their use of sex industry services. So yeah, it is. There are a number of cases that have dealt with allegations in the sex industry more general. So um, not necessarily pertaining to sex work specifically, but there was a lawsuit with the BDSM Society in Vancouver. And they made a statement about one of the dungeon masters not being a great dungeon master for all sorts of reasons. The dungeon master did sue the Vancouver Kink Society. And then there was another lawsuit in against an individual, and she was a sex worker and it was her partner. So we are seeing that, but I can't think of any cases that have made it to trial around bad date lists, but it is definitely something I would be cognizant of. I mean, these lists and Whisper Network has always been how people keep themselves safe, especially in marginalized communities. And then the defamation lawsuits is really a threat of these very important ways that we keep each other safe. That was a very long answer, but that's a really important question. Just reading the next one. Weird specific question. Have you looked at the correlation between the jurisdictions where survivors are being sued and their unfounded rate as reported in Robin Doolittle's reporting? That's actually a really interesting question around Unfounded. And so for folks who are unfamiliar with Unfounded, it was a series that was led by journalist Robin Doolittle in the Globe and Mail several years ago now. And unfounding is when police declare the report unfounded or that like it didn't happen, again in quotations. So for whatever reason, they've declared that there's just not enough evidence to move forward with an investigation or to initiate charges. So in terms of the jurisdiction, I have my own speculation there. I would say that it is definitely the unfounding of reports of sex assault definitely contributes to defamation, but to say that there's like a statistical correlation is really difficult because my sample is quite small. It's really, really difficult to measure defamation lawsuits because unlike unfounded, there's no centralized database of when lawsuits get initiated. So I really don't even know the extent that these defamation lawsuits are happening, aside from it being reported in media, case law, which is also not that reliable because only 3% of 3% of civil cases will ever make it to trial. So it's not the most reliable method. And then people reaching out to me. From the people I've interviewed, it's definitely the police play a big part in the lawsuit that is subsequent, but whether or not there's a direct correlation, I can't make that call just because of my sample size. It's not the most. It's very piecemeal at this point, given the challenges of collecting data on these defamation suits, whereas the collection of police data is, I don't want to say perfect or good, but they have better reliability in terms of collection in comparison to the civil legal system for sure. I guess that's it for questions.
Well, I was wondering then, Mandy, I know we have a few more minutes. Could you talk a bit more about your restorative justice work? It's
Yeah.
Sarah.
Oh, Oh, I see. And there's a follow-up question. If there might be an opportunity to have survivors register their cases. Yeah, actually, that's like my ultimate vision for our website is to begin collecting that data. So having a place where survivors can let us know if there's defamation action being against them or even a cease and desist letter. I would really love that to be how we begin collecting data because the governments don't seem to be too interested in collecting civil data. So that is a part of what we're hoping to for the website. Um, and also, of course, tracking through media reporting. But that tends to also have some big holes in it because the cases media tends to report on or what is when it involves public figures. So absolutely, Shireen. And I'm gonna I am also continuing this research. So if anybody has contacts or knows somebody or they themselves are being sued for defamation, I am continuing doing interviews. I'm working on a second book right now that's going to look at the civil legal system more generally in responding to sexual violence. So I am interviewing people who have been sued for defamation as well as people who have initiated legal action for sexual violence. So it's a broader book at the civil legal system for my next book. I usually have a recruitment poster on my slides, but I forgot to include it here. It is on my LinkedIn. If you are interested in checking that out, or if you know somebody or have a friend or acquaintance who might be interested in chatting with me about their experience. And yes, Sarah, to answer your question, I have after finishing up Suing for Silence, I got a shirt grant to work with. Well, I've been working with LEAF, so Women's Legal Education and Action Fund, and Community Justice Initiatives. They're a community-based justice organization in Kitchener-Waterloo. They're one of the few organizations that does restorative justice for cases of sexual harm, which is of interest to me given all of the many failures of the criminal legal system for a multitude of reasons. For those of you maybe unfamiliar with restorative justice, it is a not, well, I guess there's a few different forms that it can take, whether it be in tandem with the criminal legal system. There are provisions in the criminal code that allow for restorative justice or many times outside of the criminal legal system altogether. And again, restorative justice can take so many different forms, whether it be through mediated or facilitated dialogue. So both parties do work on their own and then come together and talk about what had happened. And it is a very structured process. There's a lot of steps involved. It doesn't just happen. And or it could be letter writing. It could be, there's a wide array of what restorative justice could look like. And so I did a report with LEAF if anyone's interested. I don't know if I can put it in the chat, but it's called Avenues to Justice. And we published it in 2023. It's available online if folks are interested. And we looked at the legal barriers to accessing restorative justice for sexual harm. And what we found was that there was a growing interest because of things like the unfounded case, and just several very high profile criminal trials that had really made people question whether the criminal legal system was the appropriate avenue for justice for addressing sexual harm. Um, One of the barriers that we found through that research was that there is policy in many of the provinces, such as Ontario, where I'm situated, that prohibits sexual offenses from being diverted into restorative justice, which more recently, I don't know if anyone's been following the news with the Hockey Canada case. There's been several survivors and myself. I did an interview recently with being interested in non-carceral, non-criminal law options for responding to sexual harm and providing justice. So I think that I think in the coming 5 to 10 years, there is going to be growing interest in non-legal approaches to addressing sexual harm and accountability. With that being said, I also don't want to romanticize it because several of the women that I interviewed for Suing for Silence were women from marginalized communities who opted to go the restorative route, who opted to uh, invite the person that had caused them harm into accountability circle. And they did so intentionally because they were from racialized communities or other marginalized communities and did not want the person who harmed them criminalized. And in turn, the person who was accused or invited into the healing process then sued these women in defamation. So I also have my hesitations about it. I don't want to romanticize it as this is the perfect solution, because I have also seen really well-intentioned women who don't want to perpetuate harm, attempting to engage in these types of restorative processes, and then being subjected to the legal system by the person who caused them harm. Not to end things on a kind of depressing note, but that's just what I've seen in some of my research with survivors. But I do have another report that will be coming out soon. It's going to be jointly released by LEAF and Community Justice Initiatives, likely in the fall. That's going to look specifically at attitudes towards the prohibitive policies for accessing restorative justice in Ontario. And our ultimate policy recommendation is that Crown policies that prohibit the use of Section 717 of the Criminal Code, which is the alternative measures, be rescinded and amended in collaboration with survivors and organizations that provide services for sexual assault survivors.
Thank you so much, Mandi. And one more question was messaged to me, if that's okay, if you have just
Yeah,
a
of
minute.
course.
The question is, sorry, can you talk a bit about some of the non-legal pathways available to individuals who experience sexual violence and why they might choose these options over formal legal actions?
Oh, absolutely. So, um, the criminal legal system and the civil legal system, I guess if you're looking at the research around what the justice needs are for survivors of sexual violence, it's often things like accountability. It's things like feeling safe. Maybe it's some form of like restitution or, for the harm that had been done. The criminal legal system is unable to do any of those things. Report to police, the only possible outcome is they're acquitted, or they are face some sort of consequence in terms of imprisonment or not restraining order. I was going to say probation. So for many survivors that I've talked to and within the research, it's not so much about wanting punishment, but those other things that cannot be necessarily objectives that cannot be met through the criminal legal system. I've also been interviewing many survivors who have initiated civil legal action, so suing either institutions or individual perpetrators. There is maybe some leeway to get some of those things that I just mentioned, but really the intention of the civil legal system is to give money. And money is not necessarily accountability. It's not an apology. It's not a recognition of harm. So non-legal options available to survivors, such as restorative or transformative justice, create more space to have dialogue, to ask questions, to come in to have a communication, whether that be face-to-face or through letters or video calls. It can take a many different forms of what that might look like. There's a woman named Marley Liss who's spoken very publicly about her experience engaging in a circle process with the person who caused her harm, and how that process was very transformative for her as an individual in terms of like not necessarily having him justify what he had done, but better understanding his experience of that situation, and taking accountability for what had occurred. I've also spoke to a woman that spoke at the event I held recently. She it started a restorative process. So oftentimes in like the both parties will kind of be doing their own work on their own. And then once the facilitator kind of assesses and says, okay, I think we're ready to bring everybody together, then a dialogue, a facilitated dialogue will happen. But in this case, the woman and the guy who had assaulted her, he never came to a place that the facilitator felt it would be appropriate or ready to take any accountability for what had occurred. And even though they never got to that dialogue together, the process of engaging in it and the work that she did on her own, she felt that was justice for her. And while she didn't necessarily get the accountability she had hoped for, it was very healing for her to do that work, to eventually, faith was a big part for her as well in that process. So again, I don't want to romanticize it as the perfect alternative to the criminal legal system. However, I do think that it is an option that could be better resourced, and I think it should be another option available to survivors. I think right now we often tell survivors that they can report to police or they can do nothing. And I think there needs to be something that exists beyond those two options, in terms of addressing and preventing sexual harm. Oh, thank you, Sarah. And the link to the report is in the webinar chat. So yeah, and if you follow me on LinkedIn, you can see we're going to have some more publications in the area of restorative and transformative justice coming out in the next couple months.
Wonderful. Well, Mandi, thank you so much on behalf of Ava, the Frida Center, and I'm sure all of our participants. This was just a fabulous webinar. Thank you.
Thank you so much.
And for our attendees, please do take just a second to take the SurveyMonkey survey to let us know how you liked the webinar, if there are topics you'd like to see in the future, and anything else you'd like us to know.